that we have. Look at the children with cancer. Look at the site. This site is incompatible for this operation. Thank you.
Thank you, Ms. Barry. We'll proceed with Ms. Cleaver.
Thank you very much for having me here today to speak. I have family that lives in Massachusetts, and I've been recognized for doing extensive environmental work, especially on some solid waste sites. And I'd like to commend Kathleen Barry for what she's bringing up. And that's the reason why I'm here, is so we don't end up with more sites like Olin. And that's why I feel we need to have the EPA or DEC, in my case, I'm from New York. We need to have that oversight because it is health and safety. And the gentleman from New Jersey was kind enough to stay to leave his picture here. And I'd like you guys to look at that. Somebody brought up from NET, I think, about this was a case of NIMBY. Well, if it's a case of NIMBY, I'm guilty. I don't want that in my backyard. I don't want that in my neighbor's backyard. And would you want it in your backyard? And would you want your drinking well underneath that lump? Or what if it's a sole source aquifer? Those are things that really need to be addressed here. And I'm hoping that at least there will be some guidance set up for this. In Middletown, which is right next to us, we had almost the same thing. I would imagine Middletown, New Jersey Railroad with Chartwell is still, I'm not sure where that has settled about pre-exemption. And I also have to question, what happens if there is a landfill at the end of this railroad? Is that going to fall under pre-exemption too? Who's going to have jurisdiction there? If they start polluting, who am I going to go to if there's leachate leaking out into a river? These are serious issues. And also, who's going to pay to clean up the pollution when it does happen? It's going to be on the back of the taxpayers. Is there going to be bonding that NET's going to put up for this site to cover any pollution that's there? Now I'm going to go back to my what I had written. It seems like it can take a day to pollute a site and contaminate it. And then it takes 10 years to clean it up. I know I've worked with Congressman Hinchy down to our county executive, to the EPA on Superfund sites. And we're still going through, we're ahead of them, but it's a lot of work. And that's just one site. And this has a potential to be national. It could happen anywhere. It has to have some type of guidance so people know what they can do and what they can't do, and things like that don't happen. It also, for all the work and the people that work in the environmental field, I think great strides have been made. From elected officials on down, they realize the problem with contamination, the problem with health issues that surround things like this. This, to me, sets it back. It's putting us in reverse. Because how are we going to deal with all of this? Are you going to have enough people? Kirk Van Tine indicated no site assessment pre-clearance. Well, that sounds good in theory, but first the EPA, they have different levels, at least my understanding, and it's a shame they're not here, that as to how far a site will get cleaned up. Sometimes they'll say that you can't build anything on it. There could be volatile vapors end up going off on these Superfund sites, and it's hazardous to your health. So how can you waive and say no site assessment? What about the workers on this site? Are they going to be using water from, where are they going to get water from? I think bailing and stuff, at least in our local transfer stations, require water as a usage. Are they going to be using water from contaminated wells? I mean, there's a lot of issues here that really need to be addressed, and I see my time's up. And thank you for today.
Thank you, Ms. Cleaver, and be assured your entire statement will be put in the record.
Thank you.
We now turn to Mr. Carter A. Strickland, Jr. from the Raritan Baykeeper and Hackensack Riverkeeper.
Thank you, Chairman and Commissioners. I should clarify, I work at the Rutgers Environmental Law Clinic, and Raritan Baykeeper and Hackensack Riverkeeper are clients of mine that we represent in a suit against New York, Susquehanna, and Western. That's our interest here. I have represented another client, Pinelands Preservation Alliance, another case in New Jersey in the JP Rail matter, which was able to shut down a facility. I raise our interest in the New York, Susquehanna, and Western case for two reasons. One, it was only as a result of our case, plus the state's action, that finally and belatedly forced this kind of condition to be changed. I'm not saying they're compliant now, but this railroad was very reluctant to comply at all. And that's relevant because that will be the inevitable result of preemption of laws. That is the lowest common denominator. That's what these sites will devolve to. The second reason I raise our litigation is that we, unlike the state, we raise federal claims under RCRA. I agree with everybody who said, and our submission reflects this, that state law is the primary law that applies to solid waste facilities. RCRA does apply at a baseline level, but it's important because the commission has suggested that, or the board has suggested that federal law somehow might be an escape, and it's not. If you look, and I'm going to direct my remarks to the text of the preemption section in ICTA and the legislative history, and rely on our submissions to address the specific questions the board had. But the text of the statute speaks of preempting federal and state law. It doesn't draw a distinction. So what the board rules here also will apply by the text of the statute to federal laws. Solid waste is regulated by states under their traditional police powers. It's true, and we certainly support permits as a key regulatory tool. Without a permit, and you've heard it described very well, police powers are essentially toothless. What the court, or what the board rules today, will also be relevant to other types of activities. Make no mistake about it. Susquehanna and Western, for example, in some regulatory submissions to New Jersey has said that, quoting, preemption applies equally to hazardous waste, medical waste, and recycling facility permits and approvals. The Brotherhood of Locomotive Engineers suggested that it would also apply to radioactive waste in this proceeding. And there's really no principled reason if solid waste facilities like this are preempted that regulations over landfills would not also be preempted. Well, I would like to focus on ICTA, and for this reason, I think it's fundamental to have a good understanding of that law and the very limited purposes that Congress had in mind when it passed it. And you don't have to take my word for it. I'm looking at the statute now, Section 10501B has this language in it, and it can't be superfluous. Congress meant every word of it. Except as otherwise provided in this part, the remedies provided under this part with respect to regulation of rail transportation are exclusive and preempt the remedies provided under federal or state law. What does that mean? It means that if the board has jurisdiction over a matter, has regulatory powers, then other federal state agencies do not. This is very clear from an initial House report. I'm quoting from House of Representatives Report 104-311. Said states retain the police powers reserved by the Constitution. This is also very clear, it's crystal clear, in the joint report adopted by the Conference Committee, which talks about the exclusivity of federal remedies and, quote, exclusivity is limited to remedies with respect to rate regulation, not state and federal law generally. For example, criminal statutes governing antitrust matters are not preempted by this Act, and laws defining such criminal offenses as bribery and extortion remain fully applicable because they do not generally collide with the scheme of economic regulation and deregulation of rail transportation. That's House of Representatives Conference Report 104-422. That's key language. The court, the 11th Circuit in the Florida East Coast Railway case, picked up on this, these two important limitations, and said, look, ICTA preempts laws only with respect to regulation of rail transportation. That is something very different from all laws that incidentally or tangentially touch upon rail, generally applicable laws. Those are not preempted. Second, Congress specifically limited the STB's ability to preempt laws to situations where there are some remedies under Part A of Subtitle 4, Title 49. The statutory remedies provided to the STB cover rate levels and such issues as economic anti-discrimination, licensing, abandonment, and sale of railroad property, operations, open track rights, financial matters, including mergers and acquisitions, and taxes. All of these substantive powers relate to economic regulation. We pointed in our submission to a Third Circuit case, Union Railroad Company versus United Steel. There, a union was precluded from bringing claims under the NLRB against the railroad because ICTA provided an explicit remedy before the STB, as the Commissioner pointed out. There is some power to govern labor relations. Therefore, there's a remedy that's preemptive. Well, what does that mean in an environmental context? Let's look at what the STB can do. It can do very little. But of course, and I don't want to belabor this point, but it's fundamental to understand its limitation on regulating existing railroads under 10906. That's been well discussed by everybody, but it's important because as you see with the principles here, these principles were involved in high tech. When that kind of operation was shut down, they're reconstituting themselves as an existing railroad to try to seek ICTA preemption, knowing full well that as an existing railroad under 10906, there's very little licensing authority the board has. The board does review acquisitions or major federal actions and decisions approving an acquisition under NEPA, but that happens at the outset. There can be conditions on NEPA, but it does very little, I would submit, to control the ongoing operations from a facility like this with the dust and water runoff that certainly concerns my clients. These upland facilities and the solid waste that comes off them are clogging up the wetlands and dirtying the streams, and it's just not right. But NEPA review is limited. We pointed out the testimony of then Chairman Buttry on June 21st, 2006, that pointed out that the overall staff of the STB is limited by appropriation to no more than 150 employees. Only a small number of those are responsible for NEPA review. And if you look at just a state like Massachusetts, they didn't say how big their program staff was, but if it's anything like New Jersey, it's about that just for solid waste alone. So the board just doesn't have the capability. They're not set up to oversee environmental laws and the inspections and enforcement that would be necessary to do so. In short, Congress did not intend for the Surface Transportation Board to effectively shape the solid waste industry. Didn't give it any remedies to do so, and because there's no remedies under the terms of 10501B itself, there's simply no preemption. I want to address very briefly the City of Woburn case, and I'd be happy to take some questions on it. That case is a case about overlapping remedies. That case involved the city trying to revisit a NEPA determination made by the board. It's really a res judicata decision. I want to briefly address the three solutions that have been floated by various parties on the board. One, bona fide railroads, limiting preemption to such railroads doesn't do anything, certainly for the New York Susquehanna situation, doesn't do anything if indeed NET is a bona fide railroad, simply because of the limitations of 10906 and the board's decision in Riverdale and other cases. In fact, the STB, to my knowledge, has never authorized or controlled or approved any waste stations built by existing railroads. The second solution floated is a closer scrutiny of exemption petitions. Again, what will the Surface Transportation Board do with that information and what standards will apply? We submit that there's too many open questions for that to be effective. And the third one, and of course this is the railroad's favorite suggested remedy, and he said it today very well and very candidly, They want to pick and choose the state law that they will apply with, what they deem, what we think applies. That's a direct quote as I wrote down. What they think are the substantive rules. I would submit to you that if they're truly concerned about a patchwork of laws, this is the ultimate patchwork. Each railroad negotiating what it thinks will apply to it is the ultimate patchwork. And it belies the logic of the patchwork argument. Plenty of Fortune 500 companies that comply with state environmental laws. In fact, the railroads themselves comply with various laws. This concept of voluntary compliance seems to be running like wildfire through environmental laws.
Mr. if you could please wrap up.
I will. 36, Mr. Chairman. We don't talk about it yet with taxes. It certainly was burdensome for me on Tuesday to pay taxes. We're not yet talking about letting the railroads off with taxes or not pay stamps on their postage, but that's the ultimate logic. If anything is burdensome, it's economic regulation. That's simply not the law. Thank you.
Thank you, Mr. Strickland. Thank you, panelists. Mr. Strickland, I'll start with a couple of questions for you, if I could. Clearly, you are well read in the law. We appreciate your participation today. I know you're familiar with the case I mentioned earlier, the City of Auburn Ninth Circuit case. You did raise the issue of an interpretation of ICTA, whereby the board may only really need to worry about economic regulation. If I understood your comment, and that was an issue that was explored in the City of Auburn case by the Ninth Circuit. In there, the court stated in its decision, in fact, there's nothing in the case law that supports Auburn. Auburn was arguing the same. Auburn's argument that through the ICTA, Congress only intended preemption of economic regulation of the railroads. All the cases cited by the parties find a broad reading of Congress's preemption intent, not a narrow one. We're going to have to wrestle with that, obviously, if we decide what to do here. You did point out some, I'll give you a chance to speak to that. Is that a minor consideration, that quote from the Ninth Circuit, or how would you reconcile that with your view?
We think it's not warranted by the text of the statute and certainly the legislative history, which does focus not only in terms of the remedies, but in the whole purposes of the Act, which was to free railroads to compete on an equal level, not burdened by their exit restrictions and whatnot, with other modes of transportation. In fact, that's really the sad thing here, is that there's many missed opportunities for environmental groups which do support rail to make common cause with them. We would like to see rail taking out solid waste. Make no mistake about it. If they're playing by the same rules as the other companies, this gentleman who invested $9 million of his own money in a facility that's protective, we certainly want to encourage that kind of investment as necessary to protect the public. City of Auburn did consider, I think it's dicta if you look at what the decision really had to say about res judicata and the ability to revisit, of a City of Auburn to revisit a board's prior decision regarding the scope of its NEPA review. City of Auburn does seem to suggest in language that, again, we consider dicta, that all environmental regulations are somehow economic. Well, that can't be squared with the Congress's reservation of police power rights to states and the very limited remedies provided to the board. And
Thank you, Mr. Strickland. I will also note that the City of Auburn case was considered by the Supreme Court and was denied cert. The same proposition was that ICTA does not limit preemption to only economic regulations. Was also held in the Second Circuit case, Green Mountain. You do point out a very serious concern, which is our authority over active railroads, not as opposed to potential new entrants, such as the one before us today, is rather limited. And do you propose that we somehow, there has been some statements to this effect today, that we figure out a way through this case to settle the field of controversy surrounding active railroads that may be involved with activities such as what we've talked about today, handling municipal solid waste, the C&D, or strictly address what we have before us today, which is a situation of a new entrant? Because the new entrant, obviously, we have a lot more authority. We have the ability to do a lot of conditions, delegate our authorities to folks who have the wherewithal. I agree with you, we are a small agency with some limitations in staff and budget. We're not proposing to send our employees all across the country to, arrest people, so we would need to delegate that somehow or contract out, and I haven't thought that through entirely. But what do you propose we do with this case today, and do you think it's reasonable and possible to actually settle the whole field of controversy surrounding rail transportation and municipal solid waste and C&D material, and survive appeal?
We do. I think it's going to be appealed one way or the other, so I don't know that you can avoid that. But as we said in a direct response to that first few questions posed by the board in their notice of this very hearing, whether we think the board should wait or not, and I think implicit in that was whether the board should limit its ruling to this case or really address the fundamental problem that's causing a lot of pain in communities that are subject to these unregulated waste stations. I think the board should. It certainly would resolve a number of issues that are taking up a lot of time and frankly causing a lot of harm to the environment. These kind of operations were in place for the better part of a year, if not more than a year, before they were stopped. Certainly more than a year, actually, now that I think about it, by 2 lawsuits that were brought on. This is a big problem, and as I said earlier, I think drawing the line on transportation will nip in the bud what's going to come down the line, which is the question of unregulated landfills, the question of unregulated hazardous waste transfer and disposal facilities. Certainly, if this is permissible, there's no logical stopping point for those. So we do think the board, we do hope the board, in the discharge of its public interest responsibilities, does address those larger questions.
Ms. Barry, thank you for being here today, and we do appreciate having someone directly from the community. It means a lot to us. I know it's no small effort for an individual to come all the way down here, sit through this whole day.
I appreciate that. Thank you.
We're delighted you are part of this process. Let me ask you, we heard from the state representative that he envisions industrial development of some nature, some type on this facility. What's your vision for this property, and would some other railroad type of operation be within your realm of comfort level? But
no.
No railroads whatsoever?
No, I envision what he envisions. We have had enough. I don't know if I stressed that enough with you. We have 2 landfills that are close by. We have a Superfund site on the site. We have another one about 3 miles away. We have been overburdened by trash. We have been overburdened by these unsightly, these types of operations. We need to improve the quality of our life and our environment. We have an opportunity. The EPA is in there. They're going to remediate to a level that we can then be accepting of. We work very closely with the EPA. We've met with them quite a number of times in their public involvement. We were involved up to this point with the Massachusetts DEP on this site. So we have a very strong desire to change the course of what is going on down in South Wilmington and North Woburn. We need to make it more inhabitable, more pleasurable, more aesthetically acceptable. And it is, I can say that nothing. And that the initial railroad proposal that was brought to us, even though it has changed threefold, was was never really brought to the community, and that's one thing I didn't point out to you, is that we have not had a public involvement open meeting. The community itself has no idea what's facing. New England Transrail has never come for an open meeting to meet our community and the public. We'd stress that. I don't know if you could actually recommend that. But
actually, we would require that if we were to, as part of the NEPA process, if we were to assert jurisdiction,
Yeah.
we would be the lead agency in the NEPA,
Wonderful.
and we would actually, that would get much more into the details. And that's
When Representative Maselli says he envisions this, it's not just because he envisions it, it's because he's heard it from the communities of both Woburn and Wilmington members. I can tell you they'll come out threefold to oppose any rail reload facility as we did in the past, and certainly this proposal, this is way over the top. This is we can't accept this.
I understand. You've made that loud and clear. Mr. Deutsch, if this were to transform again, you talked about a transforming setting here of the applicant in your view, changing its plans over time. If this were to transform into strictly a container operation, no unloading or sorting, just a truck container being placed onto a rail container, but filled with MSW and C&D, is that something that the town could acquiesce to, or would we expect to see a lot of complaints from the town about that kind of operation?
It would not be acceptable on two levels. And the first is that this site has got to be left alone sufficiently so that it can be, all the environmental issues affecting the site can be thoroughly vetted. And that is the role, that is the obligation, the prerogative of the EPA. And we are disappointed the EPA is not present today, but they have made quite clear in their written submissions to this board the inadequacy of the
somewhat cursory environmental review, environmental assessment that was conducted in the midst of the first petition and then dismissed, which was then dismissed. The EPA has to, the contaminants of this site have not even been fully characterized. So we don't know entirely what we're dealing with. And those charged with regulating and cleaning up the site don't know. In addition, the rail activity of the sort and intensity that is currently proposed by New England Transrail could have very serious implications for destabilizing the remedial steps that have so far been implemented at the site. There is Transrail has proposed to locate this transloading facility and the solid waste facility directly on top of a cap that it says it would construct for Olin. It would take over that role for Olin. It would construct the cap without providing the kind of detailed engineering data that's essential to evaluate whether the site and that cap could withstand the active loads of as many as 400 truckloads a day and 20 100-ton rail cars a day directly above it. And this site with a sensitive aquifer beneath it that's already been jeopardized. So absolutely no, that would not be acceptable under any of the...
Thank you, Mr. Deutsch. If you could answer briefly, if EPA concluded its work someday and did not object to a sealed container transload operation, would the town acquiesce with that or still have problems?
Well, it is speculative. That is to say, it's quite a hypothetical that the EPA would someday, we don't know when, given funding constraints and the lack of progress made so far. I mean, this site has been undergoing investigation on some level for 12 years, and it is the town of Wilmington and its residents who have been instrumental in bringing to the attention of the authorities, including the Mass DEP, the existence of carcinogens, human carcinogens, at the site and in the water supply. which were not previously acknowledged. And so we've got a very, very long way to go before we can get to the point of evaluating the soundness of that. If I might add, though, this site...
Let me just understand. I asked a question.
Yes.
You prefer not to answer it because it's speculative. I respect that. And Lord knows a town or city does not need to just go along with EPA or being harmly. You have every right to object to any land use if you want to.
Well,
it's a free country. I'm just trying to understand the depth of your hostility to rail operations.
Well, it's not hostility to rail operations. It's an overriding fundamental concern with the use to which this site may be put. And site assignment, which is the process that Massachusetts law requires be undertaken in respect to solid waste, which is what we're talking about here, is indispensable, because there has got to be, for a site and an activity like this, some process, some opportunity to screen sites initially for the appropriateness. And if this board granted preemption, found that such regulation was preempted, respectfully, it would be in a position of having to pre-clear sites in a similar fashion, assuming a burden or delegating to the states the burden of doing so.
Let me interject there. It's very important. Please understand, we are not proposing this agency to pre-clear in advance of EPA's completion of its RIFS work. That is not something I said very clearly at the beginning today and throughout. I hope it was heard loud and clear. This is one juncture today, and what could, if we asserted some level of jurisdiction, a very long process that may or may not result in any rail operation ever getting approved. So just please understand, we are not proposing pre-clearing in a way that would interfere with or stand in the shoes of EPA or supplant EPA's jurisdiction.
Right. I may have misspoken, and just so that I might be clear and you can fully understand my point. What I meant to suggest is that it would then fall to this board to make a determination as to the suitability of those activities for this site as a threshold matter.
Thank you. Vice Chairman Butler, any questions?
I don't have any questions for the panel, but I just like to applaud the involvement of the individuals who came down here today. It's one thing to come here and get paid a fee to come here. It's something else, again, to come down here on your own nickel, so to speak, all the way from Massachusetts or New Jersey or wherever, to appear before the board. And I applaud the chairman in permitting you to come and be witnesses today, and applaud your efforts to come down here. It's great to see people who don't pick up and move away and say, I'm out of here. It's good to see people who are going to stand and fight, and for whatever you're fighting for. It doesn't necessarily mean this or this issue, but any issue. It's very encouraging to see that civic involvement and civic interest on an individual level, and I applaud you for doing that. Thank you very much.
Thank you. Commissioner Mulvey?
Yep. I will join Doug in congratulating you for coming on down here and standing up for your towns. Let me ask you one question, though. Where does the solid waste produced by the cities of Wilmington and Woburn go today? You produce so much of it and an amount of it, and it has to go someplace. Where does it go right now?
Have the town manager answer that.
Where does your solid waste go right now? You don't recycle all of it, obviously, so.
It goes. Thank you, Michael Kyra, the town manager from Wilmington. The solid waste goes to a facility in North Andover, an incinerator in North Andover. That's
So it goes to a waste energy plant then?
A waste energy plant, right.
Is that fully permitted, and is that something which is threatening to be closed down anytime in the future, or
no,
do they have problems?
It's fully permitted. It was initially permitted back in the early to mid 1980s. 23 different communities formed something called NESWEC, the Northeast Solid Waste Committee, and all of those communities dropped their trash at that location. That organization has since ceased to operate, but many of those communities now independently go to that particular operation. Probably 21 of them.
Is that operation at full capacity now, or could it handle some more of this, some more of the materials? I mean, that are proposed to go into such, with Union Transrail, or
It's my understanding that it could handle more because it actively markets
energy?
to other communities and energy, but it actively markets the sale of tonnage to other entities, other communities, other organizations that produce trash.
Thank you very much.
Thank you.
Seeing no further questions, we'll dismiss this panel with our gratitude for your participation. It's been very helpful. You're welcome to stay as long as we're here today, and safe journeys home. We'll call forward our final panel today, Mr. Gordon McDougall, and of course we do have closing remarks, I will note, by NET afterwards. Mr. McDougall, you've been very patient. Thank you. Welcome again. You are no stranger to this board. You are always welcome here, and please proceed.
To answer the Vice President, I'm paid to be here, but we're going late, and it's overtime.
Good for you.
I'm here for John Fitzgerald, General Chairman on the UTU, BNSF, and there are no Western railroads that have been involved in this yet. You don't see the Union Pacific here, you don't see the Burlington Northern here. It's now an Eastern problem. Mr. Fitzgerald is worried that the malaise may, he's hopeful the malaise doesn't move west. And that's how he got in this case several years ago, not in a big way, but just filing papers when papers are due. And we take no position on the transportation. We're here for this bogus railroad issue. And the three railroads that have submitted statements in the East have mentioned this. And Mr. Moats today, when provoked, mentioned it. And that's the reason I'm here today, because this is a bogus operation. What do we mean bogus operation? It means it's accepted transportation. In other words, the issue before you is under 10901. Is this a transaction under 10901? That depends on if it's a line of railroad on the one hand, or whether it's accepted track on the other. If it's a line of railroad, you got a rail carrier. It's accepted track, it's not a rail carrier. Unfortunately, not by rulemaking, but by adjudication, your staff and yourselves have adopted an absolute rule that if any non-carrier purchases a single foot of track, it's a carrier. And that's what's disturbing everybody in the railroad industry. That's why we call it bogus, and why it's going to stop. We just think it's going to have to stop, just like the old undercharge thing was stopped. Unfortunately, it caused the demise of the old ICC, and hopefully we can stop it some other way. This track is either spur, industrial, switching, team, or side tracks. True, 49 U.S.C. 105.02b talks about this accepted track and its jurisdiction, but it does not give you authority. And the court of the Seventh Circuit has said you got to look at 105b2 on the one hand and 10906 on the other hand. So though we have jurisdiction, you don't have authority. Court of Appeal has ruled on that, and your staff knows that. Unfortunately, I looked at the code annotates that case isn't in there. I put it in my prepared remarks. It's 183 Fed 3rd, I believe. And I think that's the reason Jones comes in now with an affidavit. They're afraid, some of them may be afraid that your Effingham rule may not hold up, and therefore they're putting in the type of evidence, some of it that you would have before you had this absolute rule. When you had to take a number of factors into consideration to determine whether it was line of railroad on the one hand or accepted track on the other. And that's the Frankie case situation. And you looked at things such as the volume of traffic, the weight of the rail, the history of construction in the area, the number of shippers, all of that. And so they're trying to do that now, the day of the argument. I think worried, because if you look at their application, they thought this was an automatic rail carrier. They cited Effingham and Bookmatic and stopped there and didn't put in the traditional evidence. And I still don't think they put in the traditional evidence. I still urge you to say that this is not within your effective jurisdiction. You're not authorized to prove this because this is a bogus rail under 10906. And that's, frankly, our position. I would think you might open to the parties opportunity to comment on this filing of today, which supplemented some other things they said on Monday. Whereas they had gone along with this automatic carrier thing, which the railroad industry and I call bogus. Now, they went along, but now they're worried. So they're coming in with the type of things which would allow you to say it is really not a railroad, not proper, should be dismissed.
Thank you, Mr. McDougall. Vice Chairman Butcher, any questions for Mr. McDougall? Commissioner Mulvey?
You're saying on the 10906 that it's a stub track or it's not a line of railroad, correct?
It's accepted. People use the
Yeah, I don't, yeah. But we would still preempt the operation with regard to the environmental issues? Or which is what we did with that?
What you do, you said leave it alone and leave it up to the courts like the NYS and W. In other words, if this operation wants to build track, let them build track. You don't have any authority over
But
it.
in Staten Island, we preempted the environmental laws and said it was an accepted line of railroad. And so while we preempted the
That was a long time ago. That was before ECTA.
No, I'm talking about when I first came here 3 years ago. One of the first cases I dealt with was this Staten Island case where we preempted the New Jersey and New York states from imposing conditions dealing with what would happen to the wetlands in that area, but then turned around and also said it was accepted track, and so therefore we had no authority.
Right.
And that struck me as a problem at that time.
It's not a problem. You just don't have any jurisdiction, any effective jurisdiction over yard track, spur, industrial switching, and team.
But we
You
still
want to
have
make it all non-railroad.
But we still have the authority to preempt the local.
And this is only, by the way, for the construction, acquisition, operation, abandonment, or discontinuance under Chapter 109. Other features of ICTA don't have this. In other words, they have to give the shipper wants a siding, got to give him a siding. Embargoes, all those things. Mr. Clemens come down and help. But, this only applies to 10901 transactions.
Okay. Thank you.
Thank you, Mr. McDougall. We appreciate your participation, and that concludes our panels today. We now invite Mr. Van Tyne and anyone else he has on his team representing NET. It is the custom of this board, I'm told, to give the applicant the final word, and that's what we're doing now. And my notes indicate you reserved 35 minutes. You're welcome to use all of that, but you're certainly welcome not to. We'll leave that up to you. Please proceed.
I've been spending a lot of time thinking about whether I should blatantly curry favor with the board by waiving my closing, but I'm afraid there are a couple things that I've got to say. My colleagues over here have given me all these note cards of points that I really need to make, and I will make a concession by putting all those cards over here and not making them. Sorry, guys. First, let me say that now I know that I'd rather be a forklift operator. I didn't know that exactly this morning. I thought I was being funny, but now I'm sure. Seriously, though, I'm sorry that the delegation from the towns of Wilmington and Woburn is not here to hear this, but I'm sorry. I was looking for Ms. Barry and Ms. Cleaver, but we do take their concerns seriously. I want to address just one of their points first. Mr. Deutsch said that we hadn't reached out and that we had not called and talked to them. Ms. Barry made the same point late, but she did indicate in the beginning of her testimony that she was present at a meeting in 2003 with Mr. Klempner and Mr. Jones, which wasn't very professional, she said. I am told, this was before our involvement in this case, but I'm told there were 3 meetings, one in March of 2003, one about a month later, and one in June of 2003. And there was an advertisement in the local newspapers. There was the entire town council of Wilmington attended one of the meetings. At the meeting that Ms. Barry attended, Mr. Maselli also had a representative present. And so there was an attempt early on in this project to reach out to the constituency in Wilmington in a serious way, and maybe it wasn't good enough, and we apologize for that. Maybe there should have been more of it, and we apologize for that. But we're happy to do it now. And we're here now. It's 2007. It's not 2003. And we're happy to do whatever community reach out and involvement is appropriate and talk about the details of the project. That leads me to my next point, which is concerns that Mr. Deutsch expressed, particularly about changes in the project scope and how we had just revealed that we're going to be handling waste, and I believe I heard similar concerns throughout the day. I don't want to read from our pleading, but I'm holding our petition filed in December 2005, and this is the ships passing in the night phenomenon that I mentioned this morning. Beginning on page 11 of the petition, there's a discussion of C&D waste and how it's going to be handled. There's almost a whole page on MSW and how it's going to be handled. There is a discussion on page 15, and this is 2005. There's a discussion on page 15 begins, both the board and the SCA can be assured that NET intends to comply fully with all applicable substantive state health and safety regulations governing NET's construction operations. And then there's a whole page of MEDP code sections that we say that we will comply with. Then on page 18, there's a heading in bold at the top of the page. The waste handling activities proposed by NET are part of rail transportation. And there are 6 pages of description of the activities at the site having to do with waste handling and tying those activities in with transportation. Now, just 2 specifics. Mr. Kamara, in his presentation, questioned why we were shredding, and that shredding is only necessary if you're going to sort the materials. Mr. Kamara did state, though, that there's going to be a transcript. You could look at the transcript, but I'm pretty sure I heard him say that shredding facilitated the movement of the waste on a conveyor belt. And his purpose in moving it on a conveyor belt was so that someone could stand in front of the conveyor belt and pick material, metal, and others out of it. But I just want to say that I think he said that 24-inch minus or 24-inch plus was the size that was necessary to move on a conveyor belt. In NET's filing in December 05, on page 11, the last sentence on the page says, C&D will be conveyed to shredders that will reduce it to a maximum size that can be loaded into rail cars with conveyor belts. That's why we want to move it on conveyor belts, so we can load it into the rail cars. That's why we want it to be 24 inches. He wants it to be 24 inches so he can move it on the conveyor belts and sort it. We want it to be 24 inches to move it on the conveyor belts and put it in the rail cars. So, sure, the description of the projects has changed since what Ms. Berry heard in 2003. There's no doubt about it. It's been 4 years. That's one of the problems here. We've learned a lot. They've learned a lot. Some things have changed, but a lot of things haven't changed, and not a lot has changed since December 2005 when we filed this proceeding. There is a reference in this document in 2005 as well to the board's order dismissing the prior proceeding, and in that reference, quoting from the board's order, there's a reference to the weight issue. So even before we got involved, even before 2005, the issue was in the percent from what it is.
And if things change, maybe that's not bad. Maybe that means that we're getting closer to some agreement. Now, just quickly, let me comment on something Mr. Coleman said. He characterized the, I can't remember exactly what he said about the reasons why Massachusetts did not get back to New England Transrail, but I think he indicated that they never told New England Transrail that they wouldn't agree, and that the ball was sort of in our court, and they were waiting to hear from us. They were waiting for the phone to ring. I want to pass up to the board members, if I may, a copy of a letter that's in the record, and it was attached as the last page
to Exhibit A to our filing on Monday. And that's the follow-up letter to the letter that I passed up earlier. The first letter that I passed up this morning was the letter making the proposal to Massachusetts Department of Environmental Protection. This letter memorializes the fact that Massachusetts has told New England Transrail's lawyers that they do not wish to pursue this at this time, which I believe is pretty close to exactly what I said this morning. And it also says, call us if you change your mind, essentially, at the end. And so, in our view, I mean, maybe there's a misunderstanding, and we're sorry about that, but in our view, the ball was in their court, and they chose not to call us. And I will suggest, I'm not here to question anybody's motives, but I'll suggest that Mr. Coleman explained to you why they didn't call us. He said in response to one of your questions, Mr. Chairman, that why should they try to work out any conditions, that it wasn't appropriate for them to try and work out any conditions with us, that what they wanted was for you to rule that their regulation was not preempted. And until you made that ruling, they were not going to talk to us. And that's, we believe, exactly what happened. Now, there was some concern expressed by Mr. Coleman and Ms. Lim, I think, as well, about, and maybe others, about how do we know exactly what they're talking about, how do we know what NET will agree to and what they won't agree to. And the first answer is we don't know exactly what we'll agree to until we sit down with somebody and actually talk about it and talk about specific regulation sections. But as I pointed out in our 2005 petition initiating this proceeding, we did specifically cite some Massachusetts code provisions that we thought would be applicable, that we would be willing to comply with. In October 2005, at the time of the offer to Massachusetts Department of Environmental Protection to sit down and talk with them, we prepared a listing of the kinds of things that we would be willing to talk about, and not to say that at this point we're willing to agree with everything on this list, but this is a list, and it's 5 pages long. And one of the items on this list that jumped out particularly to me when I believe it was Mr. Coleman was talking, there was Ms. Lim, about tonnage limits or weight limits under Massachusetts law, and what would happen when the weight limit issue came up, what would we do? Well, the answer is I don't know what we would do when it comes up, but it's on the list. It's one of the code sections. It's on the list of things that we said we would be willing to talk to them about and we wanted to discuss with them, and they never did. Again, not to blame anybody or criticize anybody, but it's now time to, we think, get over the all or nothing approach and sit down and talk about the list, and we're ready to do that. Just one more thing in the nature of completing the record. There's been some concern that the story changes, and how do we know that New England Transrail is really going to do what they said in the verified statement of Mr. Jones that was filed this morning. Well, all I can say, I've just got a couple things to say. First, and this was from Solid Waste Management Association, I think. First, they challenged us in their brief on Monday to respond to specific questions. It would have been misleading if we didn't respond to those questions. We responded to those questions in this verified statement in plain language, direct words, and at the end of the verified statement is the verification, in which Mr. Jones verifies under penalty of perjury, under the laws of the United States, the foregoing is true and correct. That's some assurance that they're going to do what they say they're going to do. I think Mr. Jones knows what perjury means, and I'm going to talk to him about that after this hearing. And if he didn't know what it meant, we'll tell you. But I'm pretty sure he does. And I don't think he would have said it unless he meant it. But you still don't have to take his word for it. I think that the answer is what you've suggested earlier, Mr. Chairman, that you put conditions in the grant of approval if you decide to grant approval, and those conditions specifically outline what can and can't be done on the site to whatever degree of detail is appropriate in the circumstances and reasonable. And I think the test, the basic test that everybody has to pass is whether it unreasonably burdens rail transportation. We know that, and hopefully the people who have concerns understand that as well. Now, I'd like to move sort of from the negative to the positive and try and be constructive for a little bit here. And I promise I won't take too long. I'll try and talk faster. Maybe that'll help. I think there has been a lot said today, and the whole process is helpful, and I want to thank you again for convening the hearing. It has been helpful for us to hear it and helpful for you, I hope, to hear it as well. But right now, I think rather than try to respond to everything that everybody said, it would be more useful to you if I tried to give you my framework for thinking about these issues and trying to reach a result that gives due weight to everybody's concerns. It seems to me there are 3 legal issues and 2 practical issues that you'll need to address, and I want to walk through those pretty quickly because I'm sure you know what they are. I want to give you my views about how procedurally to address them. The first legal issue is, does New England Transrail qualify to become a rail carrier? The second legal issue is, do the activities at the site constitute transportation under the statute? And on the first issue about status as a rail carrier, this one's of concern to our railroad friends, CSX, Norfolk Southern, AR, and my colleague Mr. Motes in Susquehanna. First, I just want to point out that their position is interesting. On the one hand, in all of their pleadings, they urge that you do not announce any broad change in the law on the transportation issue, but at the same time, they are suggesting that you do announce a broad change in the law on the rail carrier issue. And I don't want to say that that's internally inconsistent, but it is interesting that they're concerned about new entrants, and I would say that there is some motivation there in trying to limit new entrants in the industry. I think the law on the rail carrier issue right now is perfectly clear under Effingham and the subsequent decisions, and there's no doubt that New England Transrail's operations would qualify it to be a railroad under those decisions. They're asking that you reverse Effingham or modify it in some way, adopt some new standard. And we don't take a position on that except to say that we don't think it would be fair to do it in this case after 3 years in without warning when we have proceeded under Effingham and the board has not given any indication that it's going to change that rule. So we would ask that you apply Effingham in this case on that issue. On the second issue about the law about what constitutes transportation, again, as I said this morning, this is not a new question. The issue of what kinds of activities fall within the statutory definition has been litigated for many years. Somebody said 100 years. I'm not sure whether that's exactly true, but it's pretty close to 100, I think. The biggest problem, it seems to me, on the transportation issue is, and this I think was evident during the discussions today, is not the law. The law is out there, and it is what it is, and anybody can read it. It's the semantics. It's, well, what word did you use in your filing? Did you call it sorting? Oh, no, we can't have sorting. Well, wait a minute. All I meant was I was going to take it out and put it on the ground for a minute. I didn't mean I was going to send it to the recycling when I used the word sorting. But people read into words things that are really not there. And what I was trying to do this morning in simplifying the wording of all this is to get through the semantics and get to the facts about what's really going on. And I think that's the important thing, and that's what this hearing has helped to bring out, and I think it's what a further session, I don't know what you would call it, a settlement conference or I don't know what you would call it, but a further session for the parties to discuss, avoid the labels and get down to what is actually going on and figure out what's okay and what's not okay. But I think that's a big problem in the transportation issue, what you call things and then how people understand those things. And I think we have discussed that at some length today, and I'm not sure we have anything more to add except to say that I think that as we discussed today, our view is that what we're doing is unloading things from a truck and loading them onto a rail car, and that's it. And we're not earning any revenue from anything else. There are a lot of concerns expressed by Mr. Camara and others that why would we do this if we weren't going to earn revenue? Well, number one, our costs are a whole lot lower than his because of the mode of transportation, not because we're free of regulation, but because we're using rail cars that can haul 5 trucks worth of what he has to pay the truck driver to haul 1 truck's worth, and we can haul 5 of those in a rail car. Our transportation costs are half of his, and that's, I'm sure, a concern to him. He pointed out that he alleged that we're trying to escape burdensome, costly, solid waste processing regulation. As I said this morning, though, we're not trying to escape it, and we have said and we have offered to comply with almost all of the same provisions that he complies with right now. And I don't know whether he would say that these are not the costly ones or not, but that's something that we'd be happy to discuss later on. But I think he, on the one hand, says we're trying to escape the burdensome regulation so we can take advantage of lower costs. On the other hand, he questions why we would give up the opportunity to recycle wood or metal. Well, wait a minute. If we're escaping the lower costs, then we don't have to recycle the wood or metal, right? And we come out in the same place. I don't think I need to belabor that point. I just want to reiterate that contrary to all the speculation we heard, there's not going to be any recycling, and there is an allusion to that in our December 05 pleading too at the very beginning. We're not going to be recycling or selling anything that comes into the site. Everything that happens is designed to make it go out of the site more easily and safely and without damage to the rail car. And I think that we believe it would be a major change in the law if the board were to hold that a particular commodity were to be treated differently from other commodities for purposes of the preemption analysis under the statute. I think that there is some talk today, I think I heard people saying, maybe this was the non-lawyers talking about how we're asking for a change in the law or take advantage of some loophole in the law. But I think it's actually the opposite, that the law is pretty clear, and what they're asking for would be a very significant change in the law, and the law that this board has announced over the past few years. It's not old law. It goes right up to the present day. That leads you to the third legal issue, which is whether you have the option to make that kind of a dramatic change in law right now in the context of this case. And like the issue of a change in law on the rail carrier issue, I think the answer is clearly no, not without running the risk of being reversed by a reviewing court. As I said, we're now 3 years into this matter, and I think changing the law about what is transportation at this point would be a serious matter. And I don't know that you could do that in this case. I want to talk now about a couple of the practical issues. The first practical issue, which hasn't received a lot of attention today until the last hour or so, but is how to address the environmental concerns about the site. We understand those concerns. Those concerns are real. We recognize those since the very beginning, and we've never tried to hide them or minimize them. But the answer to those concerns for this board, for the three of you, is relatively straightforward. It's not simple, but it's straightforward. First of all, your staff is going to be doing their own environmental review, as they're required to do, and as they started doing, some time ago. And we are more than happy to work with them. We did work with them cooperatively the first go-around. We understand there was some misunderstanding about what was going on at the site, and we've tried to correct all of that. We've met with them before filing the second petition, met with them and tried to understand all the concerns and make sure we disclosed everything that was going to happen on the site. And we're more than happy to work closely with the staff, with the consultants, to do whatever is necessary for your staff to complete its own environmental review. And once the results of that review are in, you do have the opportunity to impose mitigation conditions and require New England Transrail to do whatever your environmental staff believes is appropriate to mitigate any environmental impacts on the portion of the site that we're planning to occupy. And I think it's important to understand, and I hope you all understand, that the portion of the site that New England Transrail is proposing to buy from Olin is not the same portion of the site that is the cause of the EPA's current concerns about the water plume and the carcinogens in drinking water and those kinds of concerns. I don't. Another thing I'm not an expert in is environmental law, and I don't pretend to understand all of that, but I do understand that it is possible that under environmental law that one portion of the site could be developable, buildable, salvageable, I guess, and another portion of the site might not be. And what we are hoping is that when the EPA concludes its review, when your staff concludes their review, everyone will figure out that the portion of the site that we're talking about is potentially suitable for development, subject to appropriate mitigation conditions. Then with respect to the EPA's review, again, we've heard talk about the idea that that's going to take a long time. There is the possibility of imposing a condition that requires concurrence from the EPA that this portion of the site is developable, or some formulation in the nature of a condition that does not make your order effective until the environmental concerns have been resolved. Now, getting down to the final point, which is the last practical issue, and that is what I started with this morning. How do you resolve this case in a way that's consistent with existing precedent but still protects public health and safety and addresses the kinds of concerns that we heard from the people of Wilmington and Woburn? And I think that my view is that's not an either-or proposition. You don't have to follow the law at the detriment of public health and safety, and you don't have to defer to public health and safety to the detriment of your existing precedents. And I recognize that this is an important political issue, and I don't want to minimize that aspect of it. Somebody once told me that I wasn't enough of a politician and was too much of a lawyer, but I do think that you must consider, you're not free to consider this without regard to the law, and you can't resolve it just on the basis of political concerns or how you feel about it. There is a long line of cases on both the legal issues. So I'd suggest that the starting point for the board is these are not new questions. Your professional staff is the institutional memory of the board. They have seen these questions come up before, and I would suggest the starting point in resolving this case is to listen to your lawyers and your other professional staff and see what they have to suggest. I would suggest that the optimum solution in most contested proceedings is a resolution that all the parties agree to, and that's what we would like to do. We don't want to litigate this case to the Supreme Court in 5 years. One of the principals of this project is in his 70s, and he'd like to live to see the project in operation. And I think we would like to sit down and talk to people about what their concerns are. Don't talk generalities. Let's talk specifics about what are your concerns and what can we do to resolve them. And I think this hearing has gone a long way towards starting that process. I think your questions, the questions from each of you have been excellent questions and put everybody on the hot seat a little bit and raised everybody's awareness of some of the weaknesses in their own cases, and I don't accept our case from that either. But I think that it's helpful to make everybody aware that there are constraints under which this case will be decided, and that it is in everybody's interest to try to reach an agreement, because in our view, if an agreement is not reached, the law is pretty clear that state regulation that would unreasonably burden rail transportation is preempted. End of story. And the question is, whether we can reach agreement on what is reasonable and what's not reasonable. So going back to my opening again, and my general theme throughout is that we would like to resume, I guess, the dialogue with the Massachusetts authorities, and we'd be willing to do that. I had hoped we'd be willing to start today, but it's a little late today. But just to make it clear, we'll be happy to call them. We won't insist on them calling us. I think all it takes is some encouragement from the board, perhaps some facilitation in the way of providing a meeting place where people can talk, and board staff present who can sort of facilitate the process. But I think we'd be willing to give it a shot. And I think with that, if anybody still has enough energy for questions, I'd be happy to answer any more.
Thank you, Mr. Van Tine. Vice Chairman Butler, any questions?
In the interest of the hour of the day and the time of the day, I've certainly heard what I wanted to hear today, and so I'm going to, as far as I'm concerned, I'm going to excuse the witness.
Commissioner Moldy?
I normally would have questions, but again, the hour of the night, and I will pass, and thank you very much for your time and your efforts.
Well, I thank you all. I thank the board staff, and I really believe this hearing has been helpful, and I hope that we can work together to find a way to resolve this. Thank you very much.
Thank you, Mr. Van Tine. That concludes today's hearing, and we appreciate everyone's participation.